proceed.
Judge Altenburn, Judge Northcutt, and Judge Silberman, good morning still, I think, yeah. And may it please the court, Bob Goldman on behalf of the Robert Rauschenberg Foundation. Judge Altenburn, I'd like to reserve 5 minutes if I may.
That's fine.
Also, because I'll forget otherwise, we rely certainly on our briefs for anything we don't discuss here today. I want to start with what I think is a very important and simple point, and that is that there is no Florida case that says you can pay trustees for services other than the faithful, efficient administration of the trust. Not one. My opponents cite to Muskegee Lumber and the Osias case, they still talk only about paying for trust services. West Coast Hospital, the big sort of lightning rod in this case, again, is very clear on that point. It's just trust services. The Lichtman case that we talk about, there again, just trust services, and that those trust services must be segregated so that we are dealing just with trust services to form the basis of the fee. Another truth that I don't think is disputed in anyone's brief is that there is an unbroken line of cases that say obligations of a corporation are not the obligations of the stockholders individually, and in this case that would include, Judge Northcutt, the trust. And your cells, I'm probably butchering it, versus Barry, cited in our initial brief at page 39, the Beltran case cited at page 42 of our initial brief, are just examples of that. The Parker v. Shulman case, of course, puts an exclamation point on that in our area because it says in a situation much like ours, you get paid for your trust services through the trust code in accordance with the trust analysis, and you get paid for your services as a corporate employee or officer, but that's a different matter with different standards. My learned friends...
I guess the question here is, can a trustee who, in order to protect the trust, becomes a director of a corporation where the stock is wholly owned by the trust, can the trust award or give, or is he obligated to receive compensation for his role as a director of the corporation over and above what the corporation pays him?
Yeah, and
I
think I understood your...
People who are on boards of directors who
Sure.
get paid by somebody else because they want them on that board.
Well, in Parker v. Shulman, that's exactly the situation. You have the trust is the sole owner of the stock, and the person serving as trustee and as an employee. And what the court is saying is, yeah, you get fees, but you get two fees, and they're different matters and different standards, and if somebody wants to bring a corporate proceeding on that, that's what they do. Can you be that? Yes, not only can you be that, 736.0802 sub 6 of the trust code says as a trustee owning this stock, that's what you ought to do. You ought to appoint a good board that's going to ultimately do good work, and ideally that work for the trust. But at the end of the day, it's a corporation, and we have to respect that corporation and its obligations, and you might be paid under a set of standards, as my learned friend said in Exhibit 349 that I quote in the reply brief. Those are corporate standards, and you get paid that way for that work, and for your trust work, we identify what the trust services were, and you get paid for that. And so once we've isolated the trust services, then the question is, how do we pay for that? How do we quantify it? And what the Supreme Court has said is, here's our issue. We are concerned that if you take an opinion like that written in this case below, and you strike out the line that says 24,600,000 and put 246,000 because you're in Panama City, is that going to be okay? That a Lee County judge does it this way? And could it be 24,600, same information, in Key West? And the answer is, the way the judge did it, yes. But what the Supreme Court wants is absolutely not. That's exactly what they're trying to avoid starting with Roe, but certainly going on beyond that, and that's followed up, of course, by a line of cases from the different district courts of appeal, including this one in the guardianship area.
Well, is your first point on appeal that you want the lodestar system to apply and not the West, whatever it is, case law to apply?
Well, I don't view it as one or the other, and we tried to make that clear. We view them as the same thing. And if you,
how did the trial court err?
What the trial court did is definitely, I'm not being glib, but let me count the ways. And starting with your point on the lodestar, what the court did is said it's either lodestar or it's West Coast Hospital. And I don't like lodestar because I don't like the result, not because it's the law I'm sworn to apply. I just don't like the result. Okay. That's not what we ever argued, and the other side accuses us of.
There's no case that's ever clearly and expressly applied this to a trustee, and frankly, my recollection going back to when the statute was created was that it was sort of to avoid having lodestar in trust situations.
Not in the trust side. Certainly, the legislature came back on the probate side and redid the statute, definitely, specifically to do that and put in percentages and whatnot. But I'm sorry, the first part of your question, Lichtman, I think, is a trust case applying lodestar. I read the cases. My expert, who's knowledgeable in this area, also practices in this area and testified. They say he didn't, but he did. Testified very specifically that Lichtman is a trust case, and when you apply the two cases it cited, Moschel, which is a lodestar personal representative fee case, and Jones v. Dunning, which says you treat personal representative guardians and attorneys the same way for the lodestar, that's making it a lodestar case. Go back and do this. Segregate the trustees' fees and then apply these teachings. What if, Judge Altenburn, this was a guardianship case? Mr. Rauschenberg didn't die. He just got very, very sick and needed a guardianship. So you had a guardian of the property. Otherwise dealing with the same issues. It's a stockholder. So as a stockholder, appoint directors. Everything else is the same, but instead of a trust, you have a guardian of the property. What's the answer to the lodestar question? The answer is simple. Senlari, where it applies. It's the lodestar because it's a reasonable fee. And what other form of quantification when you have factors is out there? Answer, only the lodestar. That's how you applied it there. Why would it be different here? And I want to alert you to something that it's held being a human, but sometimes I read cases again and again and see something I didn't see before. The other side in this case applied the Muskogee case, Muskogee Lumber versus Hire. If you read that case, not for the proposition that, is it a reasonable fee and is there lodestar, which is the way I read it, said of course not, because lodestar wasn't even invented at that time, but just read the case. It's at a time in our country where you didn't get a fee for being a trustee. No fee under English law. And so the court was grappling with, well, now that we're a little more modern society, should a trustee get a fee? And what they said is, yes, because guardians get it and personal representatives, then called executors, get it. And all we're saying is, even if you believe, and I hope you go back and read it carefully, if you somehow think that Lichtman isn't doing what Mr. Lyle and I certainly argued was occurring below, how do you treat trustees different? How does that work? Certainly you weren't given any rationale for that from the answer brief.
Well, let me ask you, if the trial court is correct in applying the West Coast list of factors on this, and there is inadequate evidence of the time that the trustees were engaged in this over this, about a 3-year period, I guess.
No evidence.
And you look at the other, without that evidence on that, can the trial court rely on the other factors to come forth with the fee, or is that something that must be there?
Well, it must be there, but for two reasons. One, it's one of the standards in the case, but also we can't just stop with West Coast. We've got to apply the next 50 years of Supreme Court cases and district court cases. We can't, you can look at West Coast as a statute, if you will, those factors. If you put those factors in 744-108 on the guardianship side, or put them underneath the trust factors, what are you going to apply? You're going to apply the lodestar. And the reason you're going to do that is the Supreme Court's policy of consistency.
Maybe so.
Yeah, well,
when you go through the list of A through K, there were some of these when you went through didn't have much application to this case, and there's others that had great application. For example, the amount of risk assumed, given the structure here, they probably weren't taking on a lot of personal risk by doing this, even though the amounts in controversy were very, very large. But on the other hand,
even those weren't for the trustee.
In the marketplace, we all know that if you'd go into an institutional fiduciary to be the trustee on this, you'd be paying as much or more than was awarded.
No question, Judge Altenburn, and that's the thing that even in Platte, the court recognized, even in West Coast Hospital, the court expressly recognized that we're talking about a situation where people haven't gone out and gotten an agreement. That's not the usual thing. The reason, and there are just not that many trustee fee cases around the state, is because people are pretty smart about that, and Mr. Ranson, who had testified in this case, who was a former corporate fiduciary, his job was to go out and get those agreements and wouldn't let his company do a lick of work if they didn't have the agreement. And that's a very typical setting. But if you don't have it, remember in this case, you have trustees who started in 2005, never reached an agreement with Robert Rauschenberg. Robert Rauschenberg dies.
I don't really know, and does the record reflect what his level of competency was those last 2 or 3 years before he died?
The record does not reflect that. Remember that he ordered, that is in the record, he ordered one of his ultimate trustees to sign his last document, which was signed like 3 weeks before he died. So all I have is to infer he had capacity. Whether
one way or the other, Rauschenberg himself, neither in these documents or in the last several years of his life, did anything one way or the other on this subject.
That's right. But certainly these trustees didn't come to him and do a deal. Then didn't come to the ultimate beneficiary and do a deal. Just 2 years in, a little more than 2 years into the mission, said, this is where we are, and in a footnote, this is what we think we're going to take. Okay? And under those circumstances, to then turn around and a committee is appointed, and we're going to inspect this thing and figure out, we're not Florida lawyers, we're a bunch of artists, we're not lawyers at all, and we're going to go figure this out. And ultimately a proceeding's brought, and it's crystal clear from the beginning, because we asked the court, would you please take a quick look and decide what your calculus is going to be, because it'll sure ease the trial of this case. And the judge refused to do that, but they certainly knew at that point, if not long before, that we were going to require something more than just taking a percentage out of the air. And what they, I'm sorry.
Mr. Goldman, the Lichtman case talks about an evidentiary basis for the award, and the court says we do agree, while it is clear work was done by the trustees, there was no separate evidentiary basis for the trial court's award of $50,000 to the two trustees. You point out in your reply brief that this appeal is not about the sufficiency of the evidence.
Right.
That instead it's a question of the methodology, and
right.
You want the lodestar.
Right.
So if we disagree with you on the lodestar analysis, it seems you have conceded there is an evidentiary basis for the award.
I don't believe so. What we also explained in our standard of review analysis, citing the Greco case from this court and Holland v. Gross, is what we have here is a set of undisputed facts, undisputed evidence, okay? And we have the judge making a set of conclusions from that. And that is not considered something you have to simply accept. And you can, taking those, reach a different conclusion. It's treated more like a de novo analysis.
The appellees presented evidence to support a significantly higher trustee award. And the only evidence on your side, if I recall, is $375,000 based on Lodestar. And there are cases where courts have been upheld for giving less than the experts have requested. And isn't that essentially what we have here? Your client chose not to say, well, if you reject our Lodestar theory, here's what a reasonable fee would be and here's why.
Well, I can't reject, as an officer of the court, what the Supreme Court has told us it wants, which is consistency, and that's the Lodestar. But let me go back to your underlying theme, which is that there was evidence of trust services. Show it to me. Go to page 7 of the court's opinion under review. Read everything the court found that was a service. I will tell you what you will find. Every single item is a corporate service. How do I know that? Because it involves Robert Rauschenberg's art. And there's only one entity that owned Robert Rauschenberg art, and that's Untitled Press, Inc. So there are no trust services listed in that page 7 findings.
Although the court did make findings, and it was consistent with the evidence that was presented, that the nature of this particular situation supported the idea that these trustees, excuse me, one way or the other, were going to be doing what they did, either by supervising others or doing it themselves, or if they served as directors, and they'd be doing it, but they'd still be doing it to protect the beneficiaries. And the court makes detailed findings, and the witnesses seem to support those.
They make detailed findings on the question of these trust services, and they try to overlay them, no question. No records of trust services. Go back and look at how they handled all of this. P&L statements all divided nicely between the corporations and the trust. Tax IDs all nicely between all of them. Corporate tax filings all done nicely and separate. Then all of a sudden, we're going to treat this differently. And you can't do that. If you have corporate services, if you have trustee services, you have to segregate them. We are not arguing that you can't be paid for them. That's an issue that hasn't come up with respect to the corporate services. But you don't get to lump them all together, because even West Coast says it's just the trust services you're paid for with respect to that. Judge, I'm sorry, I just felt I needed to answer the question.
I'll save you 4 minutes for rebuttal.
Thank you.
May it please the court, Jim McKee on behalf of the Appellate trustees. I believe the issues in this case have been crystallized, and there really are 2 primary issues in this appeal. The first, and really the threshold question for this court, is did the trial court apply the correct law? When it applied the West Coast factors from the Florida Supreme Court's case, was that correct? The answer there I would submit to you is undoubtedly yes. The application of those West Coast factors, the trial court's order itself, is consistent with controlling Florida Supreme Court precedent. The only case that says this is how you determine reasonable compensation to a trustee, the only one, is West Coast.
What about his argument that there's been a lot of water over the dam since then, and that Lodestar, even if West Coast is the law, that Lodestar is described within West Coast, and it has a level of importance that no one seemed to have proven up much in this case?
Absolutely, Your Honor. I don't believe the Lodestar appears in West Coast anywhere. I think the cases that were cited by the appellants in an attempt to apply this Lodestar methodology, none of them are on point. None of them consider trustees' fees. None of them apply to trustees' fees.
Time consumed in carrying out the trust, that's not like a Lodestar factor?
It is certainly one of the factors.
The wages or salary customarily granted to agents or services for performing like work in the community, isn't that a Lodestar factor?
It is certainly a Lodestar factor, Your Honor. And
so I guess the thing that's troubling me the most about this case is that while there's a lot of factors in West Coast, those 2 are there, and they've been emphasized in the case law since then, and I don't get the sense that we have much evidence at all on the record on these two things.
I think the important issue there, and absolutely, time, all of the 11 West Coast factors are important to be considered. I think the issue is the West Coast factors include a number of factors in addition to those two that you just mentioned, Your Honor.
But if I knew that these three men had spent 5 hours or 5,000 hours over this, what is it, about a 3-year period that we're getting compensated for here? I mean,
sure.
I don't know whether they were spending 90% of their time making money doing something else. Literally, I don't know whether they spent a half an hour a day or whether they were working overtime on Saturdays to do this.
Absolutely, Your Honor, and that certainly is something that the trial court took into account. The trial court's order specifically mentions those factors. The trial court weighed the evidence.
How could it measure those factors if there wasn't evidence on it?
Well, there was evidence on it. There wasn't specific evidence as to the number of hours. There were no timesheets, things of that nature.
What was the nature of the evidence?
There were 11,000 emails that were submitted into evidence, 46,000 pages. 18,000
emails sitting in my delete box right now. In case they're public records, by the way.
Understood. There were certainly 11,000 emails, 46,000 pages is evidence. There was oral testimony at trial about the extent of the work that was done. The expert witnesses testified as to all of the work that was done, the extraordinary job that was done. The other thing I think that's important, and the reason that the Florida Supreme Court has announced 11 factors, and the reason those have stood the test of time, is not everything that is done can be measured in terms of hours. As attorneys, certainly we're tied to the hourly rate. There's been talk about moving away from that to really deliver value. But an example I was thinking about the other day, if I was to give a speech, if somebody wanted to pay me to give a speech, I doubt they would pay me very much. If I wanted Bill Clinton to give a speech, he's charging, I think I saw on average, $250,000 to give a speech.
But is there testimony that these guys are so unique in what they did? I mean, from what I see, what UPI did was they decided that they knew that they had a resource that the supply of which had been capped, and that they needed to bring it in and control and foster demand, and that would increase the value of the assets owned by UPI, which would increase the value of the stock of that.
Right.
But is that such advanced economics that we needed to have really super duper experts to do this?
Well, I think the testimony that's in the record, both from expert witnesses and from others, is that the selection of these trustees was an extraordinary pick of Mr. Rauschenberg. And really the experts have routinely testified that the job that was performed by these trustees was exemplary.
I don't think there's any debate that they did a very good job.
But could somebody else have done this exact job? I think the evidence says no, that they wouldn't. Here, what we see, what the record supports, was an over $1 billion increase in the value of these assets. That truly is extraordinary. So could somebody else have performed some of these trust functions? Maybe.
And what
maybe
was it
they would have been.
They did to get the $1 billion as compared to changes in the economy and maybe changes in demand cycle?
And I think that exact issue, or that exact question, I think, is answered in much of the expert testimony, and really was much of the subject of what the trial court found. He recited, I believe, on there's an entire page of the trial court's order that describes some of the just very astute, if you will, actions that were taken by these trustees. And really, there's pages and pages of trial court findings as to specifically what the trustees and how they contributed, what the trustees did and how they contributed to the vast increase in the value of this art. I believe it starts on page 7 of the trial court order. Recites, and I won't take your time to recite them now, but beginning page 7, really through the end of the order.
Open right in front of me right now. I know what it says.
Okay, absolutely. So, Your Honor, I think, again, turning back to the threshold question, if we can decide what applies, is it West Coast or is it the Lodestar, that really does crystallize what the issues are. And so I mentioned that West Coast is still controlling Florida Supreme Court precedent. I also just want to touch on one other issue, and that is that to the extent 736.0708, the statute that we're here under today, is ambiguous in any way, the legislature has made very clear via legislative history, apply the West Coast factors. Unequivocally, there is nothing in the legislative history that says, apply the lodestar, we want you to change the way you've been doing this. It says, unequivocally, apply West Coast. A few more points on that issue. The Lichtman case. Lichtman, as I think Your Honors recognized, Lichtman says there was no testimony or documentary evidence that supported the figure arrived at by the court. That's why the court reversed that decision. There was no discussion of lodestar. You apply a lodestar instead of something else. The finding was specifically that. There was no evidence. Certainly there was a tremendous amount of evidence here that the trial court relied on.
Is there anything in the court's findings or in the record that can give us some comfort as to how the court arrived at the number that it actually awarded, as opposed to the expert evidence, which was significantly higher than the ultimate award?
Well, Your Honor, I think it's the entirety of the trial court findings. There is not a specific calculation, mathematical calculation, if you will, in a trial court's order that says
the argument in your briefs seems to support the idea that had the court awarded $55 million or $45 million or $35 million or $25 million or $15 million, that we really would have no ability to review that as long as there is some evidence to say, well, the court should have awarded $60 million.
Well, I think the important thing to keep in mind there, Your Honor, is what standard of review would that be reviewed under? If we can reach agreement on what law should be applied, if we answer the first question, the second question really is, did the trial court abuse its discretion in ordering $24.6 million in the trial court's?
And usually when we're dealing with real money like that, on abuse of discretion, we still want to see sort of the thought process the judge went through. And I guess one of the things that does trouble me is I've got the laundry list of findings in this order, and then I've got, what is it, $24,600,000. Well,
right.
How does one translate to the other?
How does one get from here to there? It's not intuitive to me as to exactly what the trial judge did to do that, and if I have to decide whether his reasoning was an abuse of discretion, it's a little confusing in this case as to how to do that.
Well, Your Honor, certainly, as I think Your Honor mentioned, there's certainly a wealth of expert witness testimony directly on point that testified as to what reasonable fees should be, what would these fees be, if I believe the appellant...
From this record, I guess, if it was higher than $380,000 and lower than $55 million, then the trial court can't abuse its discretion.
I think there's certainly a range there that the trial court, if the trial court had awarded $50 million, could we say that it's an abuse of discretion? I submit to you, probably not. If the trial court had awarded...
That's an awfully big range we're talking about that is within the bell curve of discretion here.
Well, and the Florida Supreme Court certainly has said in West Coast, and the legislature said when it passed the statute, the relevant statute, these are the 11 factors that we want trial courts to consider. Trial courts make determinations all the time. They have to weigh the evidence. They have to make findings and provide opinions. Well, that's certainly what the trial court did here. The fact that the number was not specifically what anyone testified to, I think if we were dealing with, the trial court said $51 million was testified to by this expert witness, I'm awarding $51 million. I think that could actually give you comfort that the trial court didn't do that. The trial court sat down, weighed all the evidence, and said, I'm not going to award $51 million because an expert said $51 million. I'm going to look at that. I'm going to look at all the rest of this evidence and say, what am I finding is reasonable? What do I think is reasonable compensation? I think that's exactly what the trial court did. I don't think there needs to be...
Help me out with the facts of this. What is the length of the period of time that we're getting compensation for?
I believe 4 years is what we were looking at, Your Honor.
From the date of death until... Is that when it kicks in, or because they don't ask for fees for some period before he died? Apparently.
Right. I think the period that we're here on today is 4 years, if I'm not mistaken.
So this quantity of money is being paid for the services of 3 men for a total of 4 years.
4 years, Your Honor, absolutely. Which and their services.
12 man years, if you will, of work.
I believe that the trial court's testimony or the trial court findings support the fact that in that 4 year period, relatively short period, there was a $1 billion increase in value. Certainly, the trustees did their job, did it incredibly well. The $375,000 award that's urged by the appellants would equate to probably around a little less than $100,000 to be split among 3 people per year. That is unreasonable. The $24.6 million, when you look at all of the evidence that was testified to, when you consider the exemplary job that they did, when you consider the over $1 billion increase in value, certainly is reasonable. Certainly the trial court performed its duty, certainly made findings, certainly found that the $24.6 million was reasonable.
Here's one of the things, though, that's interesting about West Coast, is the court ultimately concluded that even though there was evidence to support the award and potentially even a higher award, the court then concluded that the award was beyond what the court considered to be reasonable, and then it lists some of the factors in light of the income received, simple nature of the trust, corpus, minimum management, and so forth. And what we have here is testimony that supports much of the work or describes much of the work that was done to try to build value in the trust. But there are probably a few people who would look at this and say, this is a shocking award, and it's higher than somebody might consider reasonable. So I guess the question becomes, at what point do we affirm saying, well, it's within reason, or we say we need more explanation from the trial court as to how it picked that specific number?
Sure, and West Coast, you're absolutely right. I think the important things that are in West Coast, the court did, as you mentioned, specifically mention that this was a simple trust. I think there's even some argument in there that it's hard to probably be hard to find a simpler trust than that. The evidence in this case, on the other hand, was that this was an incredibly complex trust. This was not just a run-of-the-mill, let's find somebody to take the income in, write checks out. This was not that. This was an extraordinarily complex trust to administer. I would submit that if there was a trial court order, if we were dealing with an order that contained no real findings, no real analysis, no obvious analysis by the trial court where the trial court received findings and made, or received evidence and made findings, if the trial court had just said, I award $24.6 million, that's a completely different case. Was that reasonable? Who knows? What did the trial court find? Did the trial court make any findings? Did the trial court actually analyze the evidence? If we had that case before us, who knows? But we don't have that case before us. We have an 11-page, very well-reasoned trial court order where he certainly weighed all of the evidence. He even made some findings that, the $51 million number, he wasn't going to go with that. He discounted that a little bit. But he did recognize what the appellants recognized, that $51 million would not be an unreasonable number if this was done, if this trust was administered by a corporate fiduciary, if it was administered by a bank. Would that bank have raised the value of the trust by over $1 million or over $1 billion? Likely not, given the specific experience and the specific expertise that these trustees themselves had. Again, if you look at the Canacris case, I know you guys are very familiar with it, so I won't bore you with it.
Spell that, please.
Not sure I could right now.
382, 72nd, 1197.
Absolutely, Your Honor. So certainly the standard there of abuse of discretion, I think it's important. There was some discussion about the appropriate standard of review. Certainly we think it's obvious that abuse of discretion is the appropriate standard, certainly the standard that was relied upon in West Coast, and definitely the standard that applies here in considering the trial court's order. The Skinlary case, it's a guardianship fee case. It says nothing about the lodestar, just like the rest of these cases say nothing about lodestar. The Platte case, a very important section in the Platte case, says determining a reasonable hourly rate for an attorney for a particular type of legal service and the number of hours that should be expended by the attorney in providing those services is an appropriate starting point for the computation of a reasonable fee in estate proceedings, eminent domain proceedings, and most other proceedings. Platte does not apply to, and it never says that a lodestar should apply to non-attorney compensation. The portion, so Platte talked about attorney's fees, apply a lodestar to attorney's fees. The only thing it says, even about personal representatives' fees, is they can't be based solely on a percentage. And the reason the court said that was because it was inconsistent with legislative history. The court looked to the actual statute at issue in Platte and said, it used to say you can award based on a percentage. Now they've changed it, so we're going to interpret that as meaning they don't want us to allow an award based solely on a percentage. So I would submit to you that Platte was not intended to be some overarching, we're going to abrogate West Coast, we're going to say that West Coast doesn't apply anymore, we're going to say apply the lodestar even for non-attorney's fees. It was simply a case that applied in part to attorney's fees and then in part to personal representative fees solely to say that a percentage fee-based award is not appropriate.
Take a moment and address the director versus trustee issue.
Absolutely, Your Honor. That is an issue that I believe, as your honors noted earlier, the trial court specifically considered and rejected. The trial court found that the services that were performed by the trustees appointed themselves as directors, and the trial court found that those services were part of a strategic plan that they had put into place. They knew what they wanted to do. They knew what they wanted to do with this artwork that was really the main asset of this trust. There was expert testimony that established it's customary as part of the general services to be provided by trustees for a trustee to maintain a fiduciary officer on the board of a closely held corporation. That's exactly what we're dealing with here. And for such individuals to be the dominating factors in the operation of the business, as was true here. The court further found, as a matter of fact, that the services of the trustees were inextricably intertwined with the trustees' actions as directors of UPI and RRI, these two corporations that we're discussing. This was all part of a very prudent, as the trial court found, strategy to secure the works of art, to preserve their value, not to flood the market. This was not, there was an assertion in the initial brief that it was just business as usual in these corporations. It absolutely was not. If it had been business as usual, there would not have been, I submit to you, that increase in value, that $1 billion increase in value. That's supported by the expert witness testimony.
When assets were transferred to the foundation, which I gather almost all of it has been at this point in time.
I believe that's correct, Your Honor.
Were they transferred the stock of UPI, or were they transferred the artwork?
I don't know the answer to that question as I sit here today, or as I stand here today. I assume it was the stock of UPI and RRI, because from a legal standpoint, that is what held, those corporations held the artwork. But certainly the trust documents and the intent of...
Didn't dissolve the corporations and then distribute the assets from within the trust as compared to the stock?
I don't know the exact answer to that question, Your Honor, as I stand here today. The case, one of the cases relied upon by the appellants is the Parker v. Shulman case. Parker v. Shulman stands only for the proposition that compensation, corporate compensation, for an officer or a director of that corporation cannot be addressed in a probate proceeding, meaning that an argument that corporate compensation is not reasonable cannot be addressed in a probate proceeding. So Parker said, what we're going to look at is, as trustees, everything you did as trustees, we're going to compensate you for that. We're going to determine what's reasonable. And Parker never says that can include operation of a business, as occurred here. Parker just says, anything you received from the corporation, file a separate lawsuit. If you want to challenge that, you file a separate lawsuit. That's not for us to look at as part of the probate court. Here, we don't even have that issue. We don't even have this potential double-dipping issue, because the trustees, even though they did not have to, the trustees said, anything we received from the corporation, we're going to let the trial court take that off of what we received as trustees. So we don't have the double-dipping issue. I think the corporate versus trustees issue can be easily discarded.
You've got about 2 minutes to wrap it up here.
Absolutely, Your Honor. The last thing I'll touch on, expert witness testimony. Certainly the standard of review there is abuse of discretion, not de novo review. There is an entire section of the trial court's order that goes through the Daubert standard, recognizes that the trial court weighed the evidence under Daubert, found all of that evidence admissible.
Bring that up. Why is Daubert the standard? When did the Supreme Court adopt Daubert?
I believe it was sometime in the 2000s, later in the 2000s.
The legislature did that. When
the legislature did, you're right.
Did the Supreme Court create a rule of evidence that says we're going to be a Daubert state?
There is a Florida Supreme Court decision, and I forget the name off the top of my head, Your Honor. I believe it specifically discusses the Daubert standard and its application. But certainly, from a standard review standpoint, regardless of whether it's Frye or Daubert, certainly abuse of discretion has always been the appropriate standard of review.
Standard Frye is de novo, which is a little bizarre, but that's what the law is. We're supposed to review Frye standards de novo.
The Florida Power and Light versus Jennings case, Your Honor, is one that we've cited in our brief for application of the abuse of discretion standard. We had cited Doctors versus the Department of Insurance as another case that supports that, and that states, we apply the well-established standard of review that acceptance or rejection of expert testimony is a matter within the sound discretion of the lower tribunal, and such decision will not be overturned on appeal absent a showing of abuse of discretion. I'll stand on my briefs for the remainder of that argument, but certainly, Your Honor, the expert witness testimony was appropriately admitted, and we would respectfully request that the trial court, that this court uphold the trial court's order. It certainly is not an abuse of discretion. Trial court certainly applied the correct law.
Okay.
Thank you, Your Honor.
Mr. Goldman?
What you're being asked to do, and what the judge clearly did, and this is so critical, and I've tried to search for why, and the best I can think is there's so many big numbers about Robert Rauschenberg art being tossed around in this record, and so many points about his notoriety that no one can see the $375,000 as an appropriate trustee fee given those numbers. And the reason for that is a failure to observe the fundamental principles of corporate law, trust law, and the nature of this estate plan. Not everybody's estate plan is the same. Most trustees get an agreement, and by the way, if they throw out a high number, then the agreement's rejected, and maybe they have to go get another trustee. But that's a real problem here, because when you sit down and think about it, this is a complex trust because of the Rauschenberg art. Trust is holding stock. There's not one witness that testified that you get paid for holding stock. Not one, and it was the stock that was transferred, Judge.
Of course, the stock's value is not the same as the value of the art, but it's dependent upon the value.
It very well, obviously.
Stock's probably a lower value than the art, but it's still a value.
That's true. That's true. But
and, you're asking someone to. The position of the foundation has been that these three men should have become fiduciaries responsible for upwards to $500 million worth of assets of corporations in exchange for $33,000 a year.
That's not correct. That is absolutely not our position. And thank God we're here. Because our position is that if you do a job as a trustee, it's just a pass-through trust. You're holding a stock, you hand it to these people after taxes is paid, the precise language in the trust, you don't get a giant fee for that. If you've done the significant work the court found in this case as a corporate entity, the only one that owned that art, lawsuits, they're filed in the name of UPI, the brilliant work, fine, get paid for that. The bylaws of both corporations, Judge Northcutt said, directors pick your fee, and they did that.
Assuming I'm a trust and I've got a $500 million worth of Ford Motor Company stock in it. As a result of that, I want one of my trustees on the board of directors of Ford Motor Company. So that's done.
Sure.
Is it inappropriate for the trust to pay that trustee money as a trustee for doing an extra good job as director of Ford Motor Company?
It not only is, Mr. Ranson testified to that when he pointed out the example of his putting one of the trustees, somebody from his firm, on a board. You get paid. You get paid an hourly thing or whatever corporations get paid. And that's Parker v. Shulman. They can say it's not, but when we're dealing with obligations of corporations, we can't just say this is an area of the law we don't like and it's inconvenient.
From paying the trustee more to perform the
That's right, and that's, by the way, that's West Coast too. You get paid only what you did as a trustee from the trust. Other things you did, you get paid for it. As an accountant for the trust, you can get paid for that. Statute's clear on that. As an attorney for the trust, you can get paid for that, but you've got to segregate those services. It's just so important. Now, quickly, the 11,000 emails. Go to the last 20 lines of the cross-examination I did of Mr. Grutman in the record, where I brought up the 11,000 emails. He's one of the trustees. Mr. Grutman, how many of these were for trust work? I don't know. How many of these were for corporate work? I don't know. How many of these were RRI? I don't know. And so I asked the judge then to go back and strike that exhibit, which was sent in as a summary, and the judge denied that. But to say that that somehow supports them is silly. And what you pointed out about this, Judge Silberman, 55 million to 380,000, I think it was you, Judge Altenberg, think about that. And think about what the Supreme Court said. We reject respondents and amicus's construction of a statute which would allow one judge to set reasonable fees in an estate proceeding solely on the basis of a percentage value of the estate, comma, a second judge to set attorney's fees in a similar estate proceeding based on the lodestar method, comma, and a third judge to set attorney's fees in a similar estate proceeding by using a combination of both. That's what we're talking about. Here, just like personal representatives, Moschel case says lodestar if there's not an agreement. Guardians, you guys have said you must follow the teachings of Platte, despite what they say, if there's no agreement. And attorneys, the same thing. Why on earth are we going to treat trustees different in the unusual circumstance, Judge Silberman, where there is no agreement, there is no understanding, there is no prior court approval? Respectfully, I think the case has to be reversed, as you've hinted, for reasons that it just doesn't explain itself. But to send it back down and not tell this court that Lichtman applies and we're not going to be in conflict with it, that Parker v. Shulman applies and we're not going to be in conflict with it, to not instruct the court that way, boy, it's just to spend another series of years on this case involving charitable money that could otherwise be used for good causes. Thank you very much for your time. I'm sorry if I went over. We do ask that the court reverse and remand. We would ask the court that it do it as in Wortman versus Bell and use the testimony of Mr. Lyle to ask for a final judgment, but we understand if less than that, the court remands.
Thank you. Concludes the docket.